Jacob.
Yes, my lords. When the appellants set out their case in the request to this court for permission to appeal, at paragraph 7 of the introduction, they suggested there's a point of wide significance here, no doubt in attempts to attract the attention of this court. And they said that
it worked.
Sorry?
It worked.
It did. Very good, very astute of them. And the point they said there was where a statute concerning the acquisition of rights relating to property and similar rights is silent as to the effects of procedural non-compliance.
Which page number?
It's page 18 of the core bundle.
Thank you.
So I'm reading from paragraph 7 of the introduction to the addendum to the PTA form. So they refer to the issue on the appeal being discrete, but then they add that there's a point of wider significance where a statute concerning the acquisition of rights relating to property and similar rights is silent as to the effects of procedural non-compliance. How should the consequences of such failure be determined by the court without impermissibly rewriting the statute? And just by way of introduction, on this broader question of how one should determine the consequences of procedural non-compliance, the respondent's position is that the Court of Appeal erred in Nat and Osman. It took a wrong turn in that case by seeking to create two categories of statute with two tests for ascertaining the consequences of non-compliance, with apparent bright-line rules between these two tests as to, in one category, one can consider substantial compliance, in the other one cannot. In one category, one can consider actual prejudice, in the other, one cannot. And I submit that this is a chance for this court to correct that wrong turn and put us in the position where we have a simple one test fits all. The outcome may be different depending on the statute concerned and the non-compliance concerned. But in my submission, the actual way of approaching the test and the considerations that the court can take into account in deciding what the consequence should be the same, irrespective of what statute you're dealing with. And in my submission, that is to focus on the practical consequences of non-compliance, which is some terminology that I'll come to in synergy in a moment. So that's my broad submission on the broad question. On the narrow question, I submit that LM Court was correctly decided whether one applies Nat and Osman Category 1 approach to statutory construction, or if one applies Nat and Osman Category 2. I also will submit that LM Court cannot be distinguished in the way that the appellant seeks to distinguish it as to whether there's been an attempt at an attempt at compliance or a failure to attempt. I propose to try and spend around 35 to 40 minutes on the broader question, around the same time on ground one, and then 10 to 20 minutes on the second ground. So, just to start on the broad question, perhaps I can start with what Synergy actually asked us to do. Just to be clear on this, what at least the respondent's position is. So if we go to the core bundle at page 674, so at the top of 674, there's a heading of the core problem. Paragraph 14 then sets out the general problem of failures to comply and how the courts have dealt with it over the last 130 years. That talks about the mandatory directory distinction. Then just above paragraph 15, a new perspective is the heading. And then there's an examination of a number of authorities leading to the rejection of that mandatory directory distinction. The first authority cited at paragraph 15 is the London and Clydesdale Estates case. There's quite a lengthy quotation of that, which goes over to page 675. And then if we look at what is said after the quotation finishes on page 675, after the initial paragraph and between B and C, there's a paragraph stating, "This was an important and influential dictum. It led to the adoption of a more flexible approach of focusing intensely on the consequences of non-compliance and posing the question, taking into account those consequences, whether Parliament intended the outcome to be total invalidity." So in my submission, this is a focus on the practical consequences of non-compliance. One has to look at what were the actual consequences on the facts of the case. And taking into account those consequences, one then reaches the question to be decided by the court, what would Parliament have intended should be the outcome of that? This is similarly stated if we go to the bottom of page 676, paragraph 18 refers to a subsequent House of Lords authority to similar effect, being Attorney General's reference number 3 of 1999. It explains how there it was a question of whether the police were in breach of a duty under statute to destroy fingerprint samples, and what were the consequences of a breach of that duty. And if we go to the top of page 677, having said that the House declined to apply the mandatory directory distinction at 677 at the top, it says, instead the House adopted the reasoning of Lord Hailsham, concentrated on the consequences of non-compliance, and addressed the question, what, in light of the consequences, must Parliament be taken to have intended? So again, I say this supports what we're looking at here is what in practice were the consequences of non-compliance. In light of those practical consequences, what would Parliament have intended to be the outcome? Finally, if we go to page 678, paragraph 23, it says, having reviewed the issue in some detail, I am in respectful agreement with the Australian High Court that the rigid mandatory and directory distinction and its many artificial refinements have outlived their usefulness. And then it references back to Attorney General's reference number 3. So instead, as held in Attorney General's reference number 3 of 1999, the emphasis ought to be on the consequences of non-compliance and posing the question whether Parliament can fairly be taken to the intended total invalidity. And if one goes back to the Attorney General's reference citation, that's paragraph 18, and there it is clearly stated one's concentrating on the consequences of non-compliance, and then one goes on to the question, well, what would Parliament have intended in light of those consequences? So on that approach, I say that one can look at actual prejudice on the facts of the case, because that's one of the consequences that's arisen as a result of any non-compliance.
I think that's what Lord Steyne did in paragraph 24.
Yes, on the facts of that case, you're right, my Lord. Over the page to 679, the bottom part of paragraph 24 talks about the prejudice to the two accused, which was not significant, it was said. And it was decisively outweighed by the countervailing public interest in not allowing a convicted offender to escape confiscation for what was no more than bona fide errors in the judicial process. So clearly, on that case, prejudice was relevant, but there were countervailing factors. So it's part of the mix, I say, that one has to take into account. So I'd now like to take you to Nat and Osman, where I say that went wrong. Nat and Osman starts at page 613 of the core bundle. If we go to paragraph 21, so this is page 618, we can see how the case was being put by the appellants there. So paragraph 21, the appellant's case on the appeal presented by their counsel, Mr. Piers Harrison, can be summarised quite briefly. He submitted that section 13.3e of the 1993 Act is what he described as a hybrid provision. By that expression, he meant that whether or not non-compliance renders the notice invalid depends on the gravity of non-compliance and its practical consequences in any particular case. In my submission, this essentially is an argument for the Synergy position and for the Respondent's position today. 22. Mr. Harrison said that in the present case, the consequences of non-compliance were of no significance and caused no prejudice of any kind to the respondents. It is not in dispute that the respondents were perfectly well aware of the configuration of the property, and then it goes on to the particular facts of why there was no prejudice there. So that's the case that was being run, essentially running the Synergy test, saying no prejudice, asking the court to consider practical consequences. The Court of Appeal discussed the matter from paragraph 24 onwards. It talks initially about how there'd been a departure from the mandatory directory distinction, talks about synergy. It then, if we go to paragraph 27, towards the bottom of page 619, says Mr Harrison and counsel for the respondents, Mr Paul Letman, referred us to a great many reported cases, both for statements of principle on the proper interpretative approach and as illustrations of the decisions of the courts on particular facts. I do not consider that it is profitable to state and analyse the facts, reasoning and conclusions of each of these many cases. It is sufficient to say the following about them. There then comes a broad summary of paragraph 28, seeking to split all of the cases into two very broad categories. Perhaps I could invite you to read. Well, it may help to read from 28 down to 32.
Including 32, did you say?
Yes, please.
At the beginning of paragraph 32, the principle is put forward that the outcome does not depend on the particular circumstances, etc. Do you know of any authority in which that was expressed as a rule rather than something derived from those authorities?
Well, the Speedwell Estates effectively states it as, so far as actual knowledge is concerned, effectively as a principle which then refers back to Tudor's case. I can take the court to both of those two cases cited and explain why I say they don't really support ultimately the principle that's being put forward there. I have referred to it in the written case respondents. Let me just see. So, well, Speedwell Estates is the first one of them, which we can find at page 696 of the core bundle. This was a case for tenants of houses under long leases serving notice on their landlords seeking to exercise the right to purchase the freeholds under the Leasehold Reform Act 1967. The regulations required the use of a prescribed form. They used the prescribed form, but the landlords challenged a failure to provide the required information within the prescribed form. So Nass and Osman relies on paragraph 24 of this, but perhaps we can start with paragraph 16 on page 702.
Paragraph 6, as it's called.
Yes, so I've put in the 1, yes. For some reason they missed out the 1, but it should be 16 looking at the paragraphs around it. So what appears to have happened here is that Mr Gerald, who was representing the parties who were said not to have complied, was making an argument based on Manai. So Mr Gerald submitted to the judge and repeated to this court that the decision of the House Lords in Manai Investment, with the full citation, requires a more benevolent interpretation of the tenant's notices. If we go to paragraph 18 on page 703, Mr Gerald is making a submission that a similar approach should be adopted in considering the tenant's notice in this case. In general terms, his point was that if a reasonable recipient of them, with the knowledge of the background facts against which they were served, would derive from them all the information that is required to be conveyed by the prescribed form, then there is no sound basis for an assertion that they were invalid. In my submission, this argument on Manai is not dealing with what we're dealing with here. This is an argument that we have complied with the statute, because if you interpret it by the way of a reasonable recipient, this is a compliant notice. So that's the argument. He's not arguing about what's the effect of non-compliance there. He's saying it's a compliant notice. Then if we go to paragraph 23, there's a general rejection of his argument. In the particular circumstances of these cases, I take the view that, save perhaps for one aspect of the notices, there is no scope for enlisting the Manai principles. Mr. Gerald's argument in this respect was to a material extent to the effect that, at the time of service of the notices, the landlords already knew all the facts about the leases entitling the tenants to acquire the freeholds under the 1967 Act. So it's dealing with the actual knowledge of the tenants as part of this argument, but it's dealing with in the context of a Manai argument to say that it's a compliant notice. And there's a rejection of that argument. In my submission, it's not dealing with consequences of non-compliance. If we go to page 705, at the bottom of paragraph 23, so the first paragraph, the last 3 lines, continuing a submission of Mr. Gerald, it seems, he said that a reasonable recipient, given the like knowledge, would also do so, and that it followed that the approach of the court in Manai supported the conclusion that the notices provided all the information they needed to. In my judgment, that approach to the present problem is unsound. First of all, I do not accept that the sufficiency or otherwise of the particulars required to be provided by the prescribed form of notice, used in cases such as the present, can or should be assessed by reference to the extent of the landlord's actual knowledge of the facts. So it's rejecting looking at landlord's actual knowledge, but for the purposes of deciding whether this is a notice that complies with the statute in the first place. It's not rejecting it for the consequences of non-compliance. The way that non-compliance is dealt with in here in my submission can be seen in paragraph 24, approximately 8 or so lines down, where there's a sentence starting, "The point, however." The point, however, is that there is nothing optional about the information required to be contained in a tenant's notice under Part 1 of the 1967 Act. Schedule 3 provides that it, quote, "shall be in the prescribed form and shall contain the following particulars," end quote. Those are mandatory requirements, and if the tenant wants his notice to be a valid one, he must comply with them. This reference to mandatory requirements is really going back to the old distinction between mandatory and directory. Under that distinction, if something was mandatory, that was the end of the matter. There was no further question as to non-compliance with it. If you didn't comply, invalidity results. It was only if something was directory, one then reached secondary questions such as substantial compliance. So, in my submission, this authority does not really assist us with the current question of the new approach in Synergy. What are the consequences of non-compliance? That's not the focus. So one cannot draw from this. When you're ascertaining the consequences of non-compliance, one cannot take into account the landlord's actual knowledge. I say this doesn't support that proposition. To the extent Nat and Osmond seeks to rely on it, it fell into error. Nat and Osmond also relied on Tudor and M25 group. That starts at page 713 of this bundle. This was tenants of flats serving a notice on the purchaser of their freehold, trying to obtain particulars of a disposal so that they could see whether they could obtain the freehold. There was a question over defects in their notices. For present purposes, I'd just like to highlight 2 paragraphs. Paragraph 15 on page 718. The sole issue for the appeal is whether the failure to state the addresses was fatal to the validity of the notice. In other words, whether the requirement was mandatory or directory. So again, this is a case where they're still using the old terminology. They haven't caught up with the Synergy approach. And
Well, they couldn't really,
Well,
of course,
because Synergy was next year.
came after, I think. So
Sorry.
a bit of an unfair
I was
criticism.
just double-checking the dates. You're right, my lord. It was 1 year before, so they were still waiting to be told about this new approach. If one goes to paragraph 27, this is the paragraph that is cited in Nat and Osmond supporting this distinction. On page 722, paragraph 27, I agree with Mr. Radevsky that the state of the knowledge, in fact, is not the material issue. See Speedwell Estates, paragraph 24. So it's simply relying on what I've already taken you to, which I say doesn't actually deal with the correct issue. So Nat and Osmond in paragraph 32, which is back on page 621, that cites Tudor's case at paragraph 27 and Speedwell Estates at paragraph 24 for the proposition that the outcome in a category 2 case does not depend on particular circumstances of the actual parties, such as the state of mind or knowledge, and also such as actual prejudice caused by non-compliance. It goes on to disagree with obiter remarks of Lord Justice Chadwick in Cadogan and Strauss, and in that case, at paragraph 48, there is a suggestion that prejudice may have been relevant if one had reached that part of the argument, but it wasn't necessary to decide it. For time purposes, I perhaps won't go there right now, but
do you have the page reference?
I'm just making sure I got the correct one. It's 539. Towards the bottom of paragraph 48, it talks about it not lying in the mouth of the landlord to assert that the failure to include in the notice information which should have been there led to any prejudice in its consideration whether to admit or reject the claim for enfranchisement. There were other cases cited to the Court of Appeal in Nat and Osmond, including Newbold and Coal Authority, which is referred to at the bottom of paragraph 31. There was a discussion earlier of which category that should be in. The Court of Appeal suggested it should be in category 2. Maybe that didn't reflect the analysis they were having of separate categories. But one thing that is important is the Court of Appeal in Nat and Osmond does not identify some key passages in Newbold and Coal Authority, which I'd like to refer you to. If we go to page 644, paragraph 69 to 70, and perhaps I can invite members of the court to read those to yourselves.
So as I understand it, you would say in paragraph 70, Lord Justice Stanley Burton is essentially stating the synergy approach.
Yes. He's clearly rejecting the two-category approach that then comes into place in Nat and Osmond. He's considering in the previous paragraph G and Nathan, which is one of the Category 1 cases, and Speedwell, which is one of the Category 2. He's obviously had a submission that there's inconsistencies, and he's taking the approach, no, it's one line of authority with perhaps different results, but ultimately there's one test. And the test he arrives at is effectively the Synergy test, yes, and he talks specifically about considering the actual or possible effect of non-compliance on the parties. So again, we have to look, I say, at the actual consequences, any actual prejudice. And it's remarkable, I say, that Nat and Osmond does not engage with this. If it's suggesting there's two categories with two separate tests, and one of the authorities that it cites in passing as part of Category 2 actually is engaged with this argument and rejected that, it's remarkable they don't actually deal with that and explain why they reject the analysis.
These are notices requiring the making good of damage to property by what, coal mining subsidence?
Yes, so they claim compensation for damage to their property by subsidence.
Yeah.
As well as this, in Nat and Osmond, I believe I referred earlier to paragraph 31, where it refers to numerous other cases decided by lower tribunals or courts below Court of Appeal, and it was not considered of any assistance really to refer to them in any detail. One of those, one can see on page 614, was an upper tribunal case of Avon Freeholds and Regent Court RTM, which I think Mr. Rainey may have given you the citation for earlier in his submissions. It was one of two upper tribunal cases dealing specifically with the right to manage legislation, which had applied the Synergy or the Category 1 approach to right to manage. So the first one of the two was Sinclair Gardens, and that's referenced in Avon Freeholds. I think you have the references. I probably don't have time to go through as any detail, but there's a discussion in Avon Freeholds of London and Clydesdale, J and Nathan, Synergy, and there's a discussion of consideration of actual prejudice and substantial compliance.
So what's the page number for that discussion?
Well, I've got page 507, paragraph 32 is a reference to the previous case. So paragraph 32, 506 to 507, sorry.
Yes, thank you.
Refers back to the Sinclair Gardens case. And then within Avon Freeholds itself, the discussion starts at page 510, paragraph 38. I'd also like to highlight paragraphs 41 and 43 on page 511, 47 and 48 on page 512.
Sorry, which bundle are we in?
This is the core bundle.
I'm so sorry, I thought you were in the interveners bundle.
Oh, sorry.
Don't worry.
No, it was cited by Mr. Rainey, but they're actually in our bundle.
So 510.
Yes, 510, paragraph 38 onwards is the discussion, and I particularly highlight on page 511, paragraphs 41 and 43, on page 512, paragraphs 47 and 48. Finally, page 514, paragraph 56, towards the end. So it was cited, it seems, in Nat and Osmond. It wasn't specifically referred to. Two presidents of the upper tribunal have both applied the Synergy approach to the right to manage legislation. After Nat and Osmond, that was then scrapped by the upper tribunal, who then followed Nat and Osmond Category 2 and applied a totally different approach where one doesn't look at actual prejudice anymore. So, in my submission, Nat and Osmond has gone wrong. It doesn't provide any real adequate justification for why it creates these two categories, and it's failed to appreciate existing authority at the time. So I ask you to overturn it to that extent and declare that we have one test under Synergy under which we consider practical consequences for the parties. Perhaps, due to time, should move on to round one. So, to start with on ground one, what I wish to start with was to look at the purpose of the right to manage legislation and also the purpose of section 79.6. I've cited some aspects of the consultation paper that preceded the statute in the respondent's written case. I'd just like to highlight some aspects in that which haven't been directly quoted in the written case. In the core bundle, if we go to page 734, it has section 3, chapter 1, leaseholders' right to manage, the introduction headed problems with the existing regime. Although long leaseholders in flats have purchased the right to live in their property, control of the management, maintenance and insurance of the property normally remains in the hands of the landlord. The leaseholders are normally obliged under their leases to meet the full cost of the landlord's functions, but enjoy little control over the quality, value for money or promptness of those services. The government believes that the landlord's monopoly over the supply of services in the property is not justified. In most cases, the financial value of the landlord's interest in the building is very small in comparison with that of the leaseholders. It then goes on to describe two ways that leaseholders can, at that current stage, remove control of the property from the landlord. One is collective enfranchisement. The other one, paragraph 3, is applying to a leasehold valuation tribunal, as it was at the time, for the appointment of a manager, effectively for poor management, which is quite a tough process, and that's explained in the final sentence of paragraph 3. So applying for a manager. The process is adversarial and leaseholders may be at a disadvantage against an obstructive landlord who can afford the best professional advice and representation. Paragraph 4 then talks about other potential remedies, including challenging the reasonableness of service charges. The last sentence of paragraph 4, again, it can be very difficult for leaseholders to find the time and resources to mount an effective claim against a well-resourced landlord. Over the page on 735, paragraphs 10 and 11 at the bottom deal with the overall objective of the proposals. Paragraph 10, the main objective is to grant residential long leaseholders of flats the right to take over the management of their building collectively without having either to prove fault on the part of the landlord or to pay any compensation. The procedure should be as simple as possible to reduce the potential for challenge from an obstructive landlord. And what we can see from this is that, as one might expect, given it's called the right to manage, it's dealing with management of the property and what the government perceives as an imbalance in who gets to manage it, and too much of a monopoly in favour of the landlord, which should be redressed in their view. It's also trying to assist those with less resources. There's a couple of references to the fact that one will often expect landlords to be better resourced in this situation over their tenants. Now, given that, and also there's the reference to the procedures being as simple as possible to reduce the potential for challenge from an obstructive landlord. So again, part of what they're viewing as the underlying objective is to try and avoid obstructive landlords being able to frustrate this process. They want to try and make it as simple as possible for tenants who may be less well-resourced. And as a general point, I would suggest that one would not expect this legislation, or Parliament would not generally intend that immaterial errors of procedure could be used by an obstructive landlord to deny the otherwise lawful acquisition of the right to manage. going specifically to the purpose of section 79, subsection 6, which we're dealing with today, we can find that in the core bundle at page 303. It has 3 classes of individual to whom the claim notice must be given. And as has been mentioned earlier, only persons given a claim notice are entitled to serve a counter notice under section 84, subsection 1. The purpose appears to be twofold. One is to give the recipient the opportunity to consider the proposed right to manage claim, and the other is to give them the opportunity to serve a counter notice, if appropriate, challenging that right. I say there's 2 important aspects of the counter notice that are relevant in considering the underlying purpose of this section beyond what I've said. First is the information that is imparted in the notice. Section 80 sets out the contents of the claim notice. 82, I'm looking at page 304 now in the core bundle. In 82, it must specify the premises and contain a statement of the grounds on which it is claimed that they are premises to which this chapter applies. Subsection 3 relates to stating the full name of each person who is a qualifying tenant of a flat in the premises and a member of the company, and the address of his flat. Then goes on to require particulars of leases. Subsection 5, the name and registered office of the RTM company. All of this information, I say, is going towards a particular part of the statutory scheme. What it's doing is it's giving the recipient the information to identify whether the right to manage company satisfies the eligibility requirements to obtain the right to manage. So they can consider, on receipt of the notice, well, are these premises to which this right applies? That's governed by section 72. So they can use the information in the notice, see what premises are you trying to obtain the right for? We'll go and look at the statute, 72. Does it comply? If it's not within that, then you're not entitled to this right. We can validly object in a counter notice and say you haven't satisfied the eligibility criteria. And that's what it's giving you. If one goes down the list, it's giving you the ability to ascertain, have they satisfied the eligibility criteria? It's not giving you information to identify whether they've satisfied procedural requirements
regarding service of notices. It's not. It is intended, surely, to give the recipient information about participation notices to qualifying tenants. I'm not quite sure whether that's procedural or substantive. It may be you would say it was substantive, because it's all part of the democratic control of the RTM company.
For present purposes, one thing it's not telling you, perhaps, is it's not telling you whether they've served other landlords.
No.
Not giving you any way of identifying if they've served other landlords.
No.
And whether you can say, I object because you failed to comply with this procedural requirement to serve somebody else as a landlord. It's not saying you have to provide a certificate of service to the landlord showing you've served everybody else. Because I say that's not really the purpose of this. Because the purpose of the landlord getting the notice is for them to check you're eligible under the statutory criteria to get the right to manage.
Yeah.
The purpose is not ultimately for them to seek to look for procedural errors to try and defeat this, which is effectively what an obstructive landlord would do. They would say, well, even if you satisfy premises, right to manage company has the correct constitution, you've got the right membership, you didn't serve one notice, aha, we've got you, procedural defect. But that's not what the information is being given for, I say, because it doesn't require that sort of information to be provided. The second point I would like to make about the claim notice is to whom is it primarily directed? And in my submission, it is primarily directed to those with management functions. The point of the scheme, the legislation, is to address an imbalance in management rights. In their written case, the appellants say, well, there are other rights that change as a result of the right to manage, relating to consents, other aspects of leases. Now, that's true, but it's not the primary purpose of this legislation. The primary purpose is to take away the management functions and give them to the right to manage company. Just because other aspects of the relationship between the parties have to be adjusted to make that work. It doesn't mean they're the primary purpose of legislation. They're ancillary to that, which is effectively what Lord Justice Lewison said in the Court of Appeal in Elam Courts, that they're ancillary to the acquisition of the management functions, which is the primary purpose of this legislation.
But if that's the purpose, it could have directed that notice must be given to anyone within the building who has a management function. Whereas in fact it looks as if you have to notify everybody who is a party to the contractual regime which is being statutorily interfered with.
It doesn't make that specific distinction, and I accept that's a point against me. But I still maintain that the primary purpose of this is to deal with management functions.
What do you say the purpose is of requiring everybody else to be sent a notice to?
What, the other landlords, etc.?
Yes.
Yeah. And guarantors.
Well, it may be, well, it may be simply a failure to consider that there will be rare cases where these are not management parties. So in the usual case, one would expect a landlord to have management functions, although not always. 6b, subsection 6b, appears to cover management parties in a tripartite lease, but it does, yes, it does extend on its face to other parties. But in my submission, there doesn't appear to be any particular purpose for those other parties to receive this notice and be able to respond to it.
Why, if Parliament wants to alter a sophisticated contractual structure between a large number of people in a big building, why is it not the most natural thing in the world that everybody whose contractual rights are being interfered with should be notified that this is happening?
Notified is one thing, given the right to object.
That's what the claim notice does.
Yes. Another way of notifying people is subsection 8 at the top of page 304, which is a copy of the claim notice going to the qualifying tenants.
Yes.
One point I was going to make is that the qualifying tenants, they get a copy of the claim notice, but they don't get the ability to object. They are affected by all of these things happening to them as well. So they are affected by the transfer of management functions. They are affected by consents being dealt with potentially by the right to manage company. So all of these things affect them as well, but they don't get the chance to object. And in my submission, the likely reason why they don't get the chance to object is that they're not being stripped of their management functions, whilst the other effects that come with the right to manage being acquired affect them. They're not having management functions taken away from them. That's why they don't need to get the right to object. I say section 796 is primarily directed at those with management functions who would be able to object because they are having their rights stripped away from them. Maybe it was thought appropriate just to have a catch-all for other parties because they will be affected, but I still maintain that the primary purpose is to enable those who have the actual management functions that are going to be taken away by the right to manage to consider eligibility and then put forward their objection if they wish to.
Qualifying tenant is given an opportunity to join, to participate, but is never given an opportunity to object on eligibility grounds. It can't say the RTM isn't a company limited by guarantee, for instance.
No. They can just join, try and persuade people from within, or they can not join, but they can't serve a counter notice saying this shouldn't happen to my provider of management services because it's not eligible.
Are there other grounds of objection apart from eligibility?
Well, it doesn't. The statute doesn't specifically restrict it to eligibility as such. The way that it's referred to in the statute, if we go to page 307 of the core bundle, section 84.2, a counter notice is a notice containing a statement either A, is you can admit that they're entitled to require it, or B, alleging that by reason of a specified provision of this chapter, the RTM company was not on that date not so entitled. So that's what it provides. You can specify a provision of the chapter which you say means that the RTM company is not entitled to require the right to manage.
So you could specify that they hadn't given notice to a landlord.
Well, it's broad enough to encompass that.
What else does it encompass apart from eligibility?
Well, I'm saying that it may be broad enough to encompass some kind of procedural defect as well. I'm drawing a distinction between eligibility and the procedure of simply serving some notices.
But tell me if I've got this wrong. The RTM only goes ahead if there isn't a majority of qualifying tenants against it, doesn't it? Is that broadly speaking right? I'm just looking, for example, at section 81(2).
Yes, so you need to have the...
You must have, as I understand it, you've got to have a number greater than one, not less than 1/2 of the total number of flats. That's just how many flats have to be occupied by qualifying tenants, is it? I'm not sure.
So you do need a certain level of membership in order to...
I suppose what I'm asking is how does the democratic principle under which all this is meant to work find its fulfilment in the rubric of the Act?
So I think it's probably section 74 dealing with membership and regulations. Sorry, perhaps not.
Yeah, 79.4.
Thank you. Yes, you've been helped by this debate. 79.4 and 5.
4 and 5, yeah.
Sorry, 70?
79.4 and 5 on page 303.
Yes, yes, I know I'd seen it somewhere.
I mean, that was slightly going through my head as perhaps explaining why qualifying tenants only get copy of a notice rather than service of the claim notice. Yeah. Because, in a sense, their interests have already been taken into account at this earlier stage under the democratic principle.
Yes, but even under that, the majority may simply wish to acquire the right to manage despite the fact they're not eligible. And the minority may have a decent point to say, well, wait a minute, we don't even have the right premises. What are you doing? And the majority say, I'm sorry, your interest has been taken into account and we're not interested because we have the majority and you don't get to do anything after this. You had your shot at persuading us otherwise. We're going to carry on with the right to manage. And unless the landlord pops up and challenges the eligibility, there's not much you can do about it.
But if half the tenants plus one don't sign up to the RTM company, then it doesn't go ahead, does it?
Yes, if they can't get sufficient majority, then it won't go anywhere. It doesn't get off the ground.
So a tenant doesn't have to object, he just doesn't sign up to the management company. And then if that tenant, together with all the other tenants who don't sign up, equal 51%, then it doesn't go ahead. I'm just trying to think why the qualifying tenant who gets sent a copy of the notice doesn't have an objection right. I'm assuming he can put his boot in by another route.
Well, my position is that the primary purpose of being able to object is to avoid your management functions being taken away from you without a legitimate basis to do so. And because the tenants are not having their management functions taken away from them, other impacts they have other impacts, but because they don't get that stripped from them, it's not a particular purpose of the underlying legislation to give them that right to object. But for what it's worth, I have referred to an extract from Hansard in the committee stage in the House of Lords. We go to page 753 of the core bundle. So Lord Faulkner of Thoroton was dealing with a potential amendment to the draft bill. The second paragraph of 753. Perhaps I may deal very briefly with amendment number 97, to which the noble Lord Kingsland referred in the debate on the previous group of amendments, but did not repeat in relation to this matter. The right granted to landlords to be a member of the RTM is a qualified one. The landlord may become a member of the RTM company only after the date on which that company acquires the right to manage the property, whereas the amendment would allow him to become a member at any time. Qualification that he gets that right only after the company acquires the right to manage is therefore a sensible, practical reason. Before it can acquire the right to manage, the RTM company is required to serve a claim notice on a range of existing management parties, including all of the landlords. That allows the recipients to satisfy themselves that the leaseholders are properly entitled to the right to manage. So, for what it's worth, a reference to serving it on the existing management parties, I say, is supportive of my argument that that is the ultimate purpose, the main purpose, perhaps a better way of putting it, of the service of the claim notice, to enable existing management parties to decide eligibility and whether they want to object.
But the right of a landlord to join the RTM company isn't dependent upon that landlord having had management responsibilities, is it? Just got to be a landlord.
No, I think it's right. They just have to be a landlord. After the right to manage being acquired, then they get the right to join at that stage.
Yeah. And they get they're sort of watered down in terms of their voting rights.
Yes.
Yes.
Would you accept that 79(6)(b) includes guarantors?
It has language broad enough to include guarantors, yes. But again, even if it does include them, I say it's not primarily directed towards them. Perhaps it comes more to a question of looking at the practical consequences of non-compliance, that there may be a difference depending on the nature of the party who has not been served, and whether they have management functions that they may be stripped of and whether they don't, which is perhaps one way of looking at how it was dealt with in Ealing Court by Lord Justice Lewison. Perhaps I can come
to... If you confine it just to management, to stripping somebody of management functions, then if they had some valid objection to the eligibility of the RTM, would you say that the notice was all the same valid?
If there's that's a very different case to what we're dealing with. So if we're dealing with a situation where there's a failure to comply with eligibility criteria, then yes, it's a far different analysis for the court. So if the court is looking at actual prejudice to the individual party, in a case where it is apparent to the court there's no eligibility for right to manage, that will be a material factor in considering actual prejudice, and it will probably outweigh everything else to say, well, this is absurd. You're saying that you can still get the right to manage even though you obviously don't comply. But in a situation like this, where you comply with all the eligibility requirements, every box has been ticked, and all you're dealing with is one procedural non-compliance to failure to serve one person who doesn't have any management responsibilities, is not having their management stripped from them, and as I think Mr. Rainey made the point, that their only point in getting the notice is so they can put in a counter notice saying, I have no grounds to object.
They can't get costs, though.
Sorry?
They can't get costs.
A
person who hasn't been served with a notice, a landlord who has not been served with a notice, my understanding is they cannot get an order for costs against the RTM. Is that right or not?
We did seem to remember me and Mr. Bates having an argument about that in the upper tribunal. I think that was his position. I was saying they could, depending on how you read the statute. So the provision on costs...
Oh, I see, yes.
Well, they don't have a statutory right to costs, but they can presumably ask for costs.
Page
311.
Page 311, I think, in the core bundle.
Yeah.
Paragraph 88. So 88.1, a right to manage company is liable for reasonable costs incurred by a person who is. It then lists the three categories of party to whom a claim notice should be served. In consequence of a claim notice given by the company in relation to the premises. Now, what I seem to remember Mr. Bates was saying is, well, if we don't get a claim notice, we can't get the costs. And what I was saying to Judge Cook in the upper tribunal is, it doesn't say in consequence of a claim notice given to you, it's just in consequence of a claim notice given by the company. So if the RTM company gives it to various parties, another party who should have got it comes to their attention, they take some legal advice on it, my submission, this is clearly broad enough for them to say, well, we can get our costs of that. And it would be hard for the RTM company to say they shouldn't get their costs because we defaulted on the procedure by not giving them a claim notice in the first place.
Yeah.
It's a pretty unattractive argument from the RTM company's point of view. So I'm not sure she actually really decided that point, but those were the countering arguments. And that's what I say again today, that the RTM company cannot avoid the cost consequences of giving a claim notice by failing to give it to somebody. I thought I might perhaps go through some of the specific challenges to the reasoning in Ealing Court that were put in the appellant's written case. Some of these have actually been discussed quite at length this morning. So the first point is the wording of the statute. The first point made was that section 79(6) uses the word must. And I say simply because it says must, that can't assist. We all know that it has to be done. We're just dealing with what the consequences if you don't do what had to be done. There's reliance on statutory saving provisions, which I get the impression the court's not particularly attracted to that argument. So I didn't propose to say much about the saving provisions other than I would support the approach taken by Lord Levitt and I think perhaps Lord Sales as well, that they can't really assist in the way that the appellants seek to use them.
79(2), subsection 2, the word may is used. That is, the claim notice may not be given unless each person required. So that the qualifying tenant has to be given, claim notice may not be given unless the qualifying tenant has had a notice of invitation to participate.
Yes.
Is there any significance in the use of the word may as opposed to must?
Well,
presumably that they still have the choice whether they want to serve a notice or not. They're not forced to because of the fact that they've given an opportunity to participate.
so, well, I mean, this is really important. You're not supposed to try and claim your right to manage until you've given the notices to all of the qualifying tenants first.
I mean, you have to give that notice. Do you agree with that?
Yes, but there's authority already on that in the upper tribunal that if you don't give your notice of invitation to participate to everybody, literally every single person, then you can't serve a claim notice. There's been attempts to challenge that, but so far I don't think anybody's got permission to appeal from that decision.
Just on the form section 79(2), I'd have thought that if you didn't have it there, it would be assumed that you have liberty to give your notices at any time. So it's cutting down a liberty which is otherwise there. So, in fact, it does have mandatory force. It's just in the particular, I would have thought, it's just the particular context. It makes sense to put it in that way.
Yes, I think I'd agree with that.
Mr. Jacob, I think probably everybody here was brought up on landlord and tenant to remember as a sort of article of basic faith that the time limits for renewing business tenancies under the Landlord and Tenant Act 1954 were absolutely strict, and you were going to go down for a certain negligence claim if you missed it by a day. I'm just trying to remember why it was said that those time limits were strict.
I'm afraid I can't.
No.
Everything depends on the context of a particular statute and a particular issue.
But nobody sought to apply a sort of, well, see if the landlord suffered prejudice by the tenant giving the notice a day late.
Well, that might be because we hadn't.
I mean, it's all long before. Of course, it's long before the cases we've been looking at, I think. But I just wonder what the reasoning had been for a very strict approach to those landlord and tenant statutory provisions.
It might be said that the synergy approach is not simply renaming the terminology. One view is that we're just simply getting rid of mandatory and directory as words, but we're doing the same thing. Another way of viewing is actually it's not simply changing the terminology, it's a new approach at looking at practical consequences and trying to work out what Parliament's intention would be in that vein.
I think Synergy sort of recognises there's a spectrum that you can move from mandatory language and mandatory effect. You've absolutely got to do that. Consequences irrelevant. At the other end of the spectrum, mandatory language, but it's, if you like, purely directory, and so breach doesn't involve invalidating what happens later, and then an area in the middle. And the sort of conceptual advance, if you like, in Synergy was to move from mandatory directory, which just covered the two ends, and say, and remember there's something in the middle. But that's just to pose the question, and what did Parliament intend in this particular context?
Yeah.
So, I mean, I would have thought it's perfectly, well, one would have to examine the context of the 1954 Act. It's perfectly possible to infer that Parliament in that context did require something actually to be mandatory with full mandatory effect.
Yeah. So, well, I'd say that is, I'd support that analysis. I wouldn't object with that. Yeah, we're not dealing with that statute. We're dealing with the context of this statute and this particular breach. And this is very far from the sort of situation, I say, where one can say this is so strict. We have to say, despite the lack of prejudice, despite otherwise being eligible, unfortunately, this court has to hold that this right to marriage claim is doomed from the start because of failure to serve. This is not that kind of case. This is very much the kind of case where you can, I say, consider the practical consequences of this and the fact that this is the height of technical objections when you have a landlord who has managed to go along to the tribunal hearing at the first year tribunal, represented, make their arguments, tried to make a lot of eligibility arguments which ultimately failed, and then they fall back on this procedural point. And by the time we get to the upper tribunal, it's simply the procedural point. It's, well, there's no eligibility problems, there's no problems with anything here. It's just that you didn't get a notice, and you wouldn't have been able to say anything if you had got a notice. And now we're here, still arguing the same point, this height of technicality. We didn't get the entitlement to serve a counter notice, despite the fact that if we had the entitlement, we literally couldn't have done anything about it, because there's nothing to say. This is very much the kind of situation, I say, where you can say it's not an absolute strict compliance or nothing. This is very much looking at the consequences and saying, quite frankly, if one can look at the practical consequences, the appellant's argument becomes absurd. It really does. If that's what they want to notice so that they can say, thank you, we now know that we got the notice. There's nothing to object about, but at least we got the notice. That's what it was all about, getting the notice. But it's not ultimately about that. It's all about obstruction, because there are benefits to landlords in obstructing the right to manage. And it's something recognised by the government when they were proposing this legislation in the first place. They were trying to avoid that, they said, by trying to make it as simple as possible. But unfortunately, there's always scope for error in situations like this. And when errors occur, would Parliament have intended that, no, we need absolute compliance? I suggest, given the background to this legislation, no, it obviously wouldn't. And I say that despite the fact that I accept the point of the appellants. The claim notice is important in the statutory scheme. I accept that. It is important. But looking at the facts in this case and looking at the consequences, the importance pales into significance when one knows that there's nothing to say in a counter notice. And if one, well, in Elam, it was decided as a Category 2 case, so Lord Justice Lewison considered that even though he could ignore actual prejudice, he still considered that failure to serve one landlord with no management functions wouldn't. Parliament would not have intended that to invalidate the whole procedure if you were with me that actually we're not in the rigid confines of Category 2, because there is no Category 2, we're actually in Category 1, where we consider all the consequences, all the prejudice. Then it would be an even easier decision to say, well, this is a case where obviously it doesn't invalidate what followed. I think that something was touched on by Mr. Rainey earlier, that if one did try to maintain this distinction of Category 1 and Category 2, Category 2, as currently understood, allows you to consider generic prejudice, but not actual prejudice. And that really raises a query as to how does one distinguish between what is generic prejudice and what is actual prejudice? Because one could just look at this and say the only thing we can consider is section 79(6)(a) says you must serve a claim notice on a landlord. In this case, one landlord did not receive a claim notice. What possible prejudice could there be from that? And leave it at that and say we can't look at the facts. We just have to decide what prejudice generically could there be. But in Elim, one started to look at the facts and said, well, this landlord has no management functions, so that's part of the fact. Is that still generic prejudice, or are we going to actual prejudice? How far can one go into the underlying facts before one passes from generic prejudice to actual prejudice? I suggest it's entirely unclear as to exactly where that line is, if there is such a line. And the best way to deal with it is to try not to distinguish between generic and actual prejudice and simply look at the practical consequences, including actual prejudice. And then one looks at what actually happened on the facts here. What would Parliament have intended the consequence to be on these facts? Not closing your eyes to some of the facts, because that will be looking at the actual state of affairs rather than the generic state of affairs. I think I've gone through that a bit quicker than I thought. I was going to move on to ground 2 unless there was a question.
If one's going to argue one shouldn't look at the facts, it indeed seems to me to be a context-specific argument. And there may be cases where you can construe the legislation as meaning that you shouldn't, that the result shouldn't turn on the particular facts in this case, in this context. It shouldn't matter whether any prejudice has been actually caused or not, because the consideration is so important for other reasons, or something like that. I mean, what I'm saying is it should be something you get out of the exercise of construction itself, not some kind of rule like in that and whatever it's called, where you come along with and say that it's because it's in this category of case that we have to approach it this way.
Yes, that sounds like a very sensible way of analysing it. I suppose at one extreme you could have a statute where Parliament actually says any prejudice is irrelevant for present purposes. That could be one extreme. And then another one, it may not say it, but it may be so important, as you say, as your Lordship says, that the court can take it that Parliament would have intended total invalidity irrespective of prejudice.
I mean, some time limits, to take my Lord's example, may come into that category. Some time limits in some legislation may have that effect.
Yes.
Doesn't matter what your excuse is in the context, it must be a complete bar.
Yes.
But it all depends on construing the particular statute, it seems to me.
Yes.
And it seems to me, if I may say, that fits with this, the spectrum idea that Synergy set up. So sometimes Parliament may expressly say, here's a rule, and it writes in, and no departure from it shall be allowed. But sometimes it'll just say, here's a mandatory rule, but one looks at the general context and can still conclude that it is intended to be mandatory in the full sense of the word. But then at other points along that spectrum, depending very much on context, maybe a different conclusion is reached.
Yes, but I'd say that is a helpful way of analysing it, and it avoids the situation of the court trying to just close its eyes to certain aspects of the case. So we just can't look at the actual prejudice as part of the overall equation. We have to strip that out and limit our consideration in a, I would say, quite an artificial way, and just trying to divorce your argument from the facts of the case and do it in a totally hypothetical, theoretical way.
I mean, I also wonder whether, the Synergy exercise, as was made clear in Synergy itself, is typically dealing with situations where you don't have any confidence that Parliament itself has faced up to the actual situation that has arisen. And so you're trying to infer what Parliament would have wished to be the position had it had those very facts to its mind. Well, it seems to me that almost inevitably takes you into the actual facts. What are the facts that against which you're asking that question?
Yes. Shall I move to ground 2? Just on ground 2, I've made a point in the respondent's written case as to what is ground 2 and what the appellant's actually entitled to argue here, because that depends on what permission was given for. The request for permission to appeal to the upper tribunal had 3 separate grounds. One was that Elim Court was incorrectly decided, but then there were 2 alternatives. One was that it could be just ground 1. Was
sorry, where is can we have a
let's have a look.
It would be
yes.
useful.
So I'm just trying to find the. Bear with me a second.
Page 83. 115, 83.
Sorry, thank you.
I think of your written case.
Oh, sorry. Yes, my written case. I was just trying to see if I could find the actual grounds of appeal to the upper tribunal. We have the permission to the first-tier tribunal, I think.
Oh, yes. 165, perhaps?
I think that's going to the first.
This is the grounds.
That's the grounds to the upper tribunal from the first-tier tribunal. It's not when
It's not the actual.
to come here.
It's not. I thought you wanted to see what permission they had to go to the upper tribunal.
Sorry, no, it was when they were seeking permission from the upper tribunal to come here.
Oh, I misunderstood.
Yes.
So, well, if we go to the decision on permission, that's at 191 of the core bundle. So, permission was sought on ground 1, ground 2A and ground 2B. One can see on page 191, permission to appeal on ground 1 was refused. And then on ground 2, which had elements A and B, it was allowed. So ground 1 was trying to distinguish Elim Court by saying that in this case, the failure to serve was deliberate. In Elim Court, the failure to serve was accidental. In Elim Court, they tried to serve the landlord and sent it to the wrong address. Here, the upper tribunal concluded that there was a deliberate failure to serve.
Sorry, did we reach the conclusion that we don't have the application for permission to appeal from the upper tribunal? Because this is cross-referring to some other document.
I think I'm right in saying it's not actually in here.
Well, you could provide it with us, but we can see the reason for refusal on paragraph 2 on 92,
Yes.
which gives some clue.
Yeah.
She's rejecting this idea that there's anything about the state of mind of the right to manage company. The one she did give permission on by way of distinguishing Elim Court was 2B, and that was a different point. It wasn't that it was deliberate rather than accidental, it was that there was no attempt to serve rather than an attempt. So the ground she refused permission on was all about whether it's some kind of potentially bad faith or deliberate choice not to do it. She rejected that, didn't give permission. What she gave permission for was simply whether it matters if you attempt to serve or if you don't attempt, whatever your reason for not attempting, whether it's bad faith, good faith, misunderstanding the law, whatever. So that's all we should be arguing about here, I say. Can you distinguish Elim Court by saying that there was no attempt here to serve the landlord rather than there being an attempt of some sort in that case?
Okay.
And the appellant's written case, I say, seems to amalgamate the two and try and argue both at the same time.
Yeah.
If we're looking just at whether there's an attempt or not an attempt...
So just so I'm clear, you're saying that the question of deliberateness and how that might have an effect just isn't before us?
Yeah, that's what I'm saying, yes.
Okay.
Because permission was refused, so it never got this far.
Yes.
There's no certificate to seek permission from this court for that.
I think, if I may say so, it would be helpful
Yeah,
in due course to actually see the notice of appeal which is being referred to.
Yes.
It's quite important whether they can argue the point they're trying to argue or not, really.
Yes.
Because it's a bit harder to argue that it makes a difference whether you actually made a feeble effort or none at all.
Yes. I'm sure we can get that to you swiftly. So as regards whether there's an attempt or no attempt, it appears to be no part of the reasoning in Elim Court that there was an attempt or no attempt. So Elim Court starts.
What was the attempt in Elim Court?
They sent it, if I remember correctly, they sent it to the flat. So the intermediate landlord in that case was just a company which did not occupy the flat. There was some other tenant in the flat. They sent the notice to reassure, I think it was called, the independent landlord to that flat, but it was not the correct address and it didn't come to the attention of that company. So I've got 2 points on this. So first, I say that there's no suggestion in the reasoning of Lord Justice Lewis in the Elim Court that this was a consideration as to why the non-compliance was found not to invalidate everything that followed. If we go to page 573, towards the top of the page, paragraph 50, he refers to Osman and Nat as the most recent authoritative consideration of the applicable principles, and he notes that it's binding on the Court of Appeal for what it decided, sets out the 2 categories as distinguished in Osman and Nat, deals with the first category at paragraph 51. The second category he deals with at paragraph 52, where he explains the outcome in such cases does not depend on the particular circumstance of the actual parties. But perhaps I can invite the court to read paragraph 52 to yourselves.
Is the final bit of that paragraph still summarising that, or is that Lord Justice Lewison sort of giving his own guidance?
I cannot recall.
All right,
immediately off the top of my head, I'm afraid.
I think it comes from that.
Oh yeah, okay. So this is just summarising Nat.
Yes, it seems that, yes, if that also comes from that, it appears to be just a summary of that, yes, and as what he understood it to have decided. He then goes on, paragraph 53, to decide whether
But would you take into account actual prejudice, as it were, or the facts, what has actually occurred? Say, for instance, an intermediate landlord was evading service, and would that be a relevant consideration? You're suggesting a bright line rule that whether attempt or no attempt is totally irrelevant, but surely there might be circumstances in which an attempt would be relevant.
That particular type of circumstance, perhaps it would, but yes. So, but that wouldn't depend. Yeah, that would really be based on the landlord themselves and their evasive nature. That would be the key fact that they were trying to evade. That would then make the attempt relevant to show that there had been an attempt at compliance, but the landlord was creating a problem there. So yes, it could be relevant in that context. It would be quite a specific context.
You may say the focus is primarily on the person who's meant to receive the notice, and why they haven't got it, so far as they're concerned, is really neither here nor there.
Yes, if you're dealing with this sort of case where there's no attempt at evasion by the landlord, the purpose of the notice is to let them consider the eligibility and object if they wish to. If they don't receive it, it doesn't make any difference whether there's an attempt or no attempt. The statutory purpose is frustrated. They can't do anything about it because they don't know about it. Why would it make it any better that somebody had sent a notice to the wrong address than if they hadn't sent it at all? Would Parliament say that it would intend the consequence to be different in each case? I say no, you wouldn't get points for trying. If you ultimately didn't get the notice to the landlord, it doesn't serve any purpose or attempt, so it shouldn't make a difference.
And I mean, I think conversely, if one was addressing Lord Stephen's situation, again, essentially you'd ask us an edgy question. If you're dealing with a landlord who is evading service, would Parliament intend that the procedure be set at naught because they've been successful in evading service? One might rather think not.
Yeah, so the attempted evasion or the successful evasion by the landlord would be a material consideration as part of the overall assessment of all of the relevant factors, yes. So I say that ground 2 cannot succeed, and hopefully we can get you the request for permission to the upper tribunal, which will demonstrate that I'm correct, that we're not arguing about deliberate versus...
But if we are, do you want to say anything about the sort of more red-blooded version of ground 2, which was advanced this morning?
There was no evidence before the first-tier tribunal as to why there'd been a failure to serve here. The first-tier tribunal inferred that it was a mistake because the same agent had acted for a number of right-to-manage companies all before the first-tier tribunal. They had, I think, maybe 8 right-to-manage companies all doing conjoined hearings. The first-tier tribunal noted that some of them had served this landlord and some hadn't, and they said, well, given it's the same agent, we infer that it was a mistake. In the upper tribunal, Judge Cook concluded the opposite and said that was not a proper inference to make. Her decision on this is...
It's page 189 of the core bundle, paragraph 49. Is that what you're...
I'm grateful. Apologies for not getting it. Yes. So the final... Yes. So she recalled that Mr. Bates had argued that failure to serve was deliberate, and he had pointed to the right to manage company's statement of case in the first-tier tribunal. So the way it worked was that the point about service was taken, saying you haven't served a claim notice on this landlord, and the statement of case put forward by the right to manage company said you're not actually a landlord for these purposes, and it raised various arguments to try and suggest they weren't a landlord, so they weren't actually entitled to be served. And the arguments were all rejected by the first-tier tribunal, who said these simply don't work as a matter of law. So in the upper tribunal, the way Judge Cook looked at it is to say that in the absence of any evidence that the failure was inadvertent, that pleading, so the pleading saying you're not a landlord that needs to be served, reads like an explanation of the reason for failure to serve, and as the FTT said, it's a compelling reason for finding the failure was deliberate.
Do we have a bundle reference for that pleading?
Don't think we have that pleading.
It's not in the bundle.
No.
All right.
I seem to recall one of the arguments put forward was that the lease was a sham. It was written by right to manage company when it did not have professional representation, which is another point made.
I think the question, perhaps of more relevance for us, is supposing that we couldn't go behind the finding, but supposing that that we're allowed to argue the point, does in principle a deliberate decision not to serve to mean is a relevant factor or not?
Well, one point I make is to say that simply saying it's deliberate doesn't necessarily tell you everything you need to know if it's relevant. So you might deliberately fail to serve because you genuinely believe, as a matter of law, that is not a landlord to be served.
Yeah.
You might deliberately not serve because you know very well that's a landlord to be served, but you don't want to serve them because they might serve a counter notice. We don't have a clear finding as to what kind of deliberate choice was made here.
No.
Given the statement of case saying you're not a valid landlord, one of the reasons may well have been a genuine belief that as a matter of law they were not entitled to be served. So I'd suggest there's no finding of bad faith in the sense of a deliberate choice, knowing they were supposed to be served but deciding not to serve them for some nefarious reason. Absent that kind of finding before you, I suggest you can still conclude that on all the facts of this case, it doesn't make any difference, because if they'd have been served, they wouldn't have been able to put forward a counter notice, and it's simply a technical procedural point of no material distinction.
And if you look at the tribunal judge's reasoning, her conclusion it was deliberate was because they pleaded that they didn't have to serve. You know, I think all she's saying, it was a conscious decision not to serve, rather than a decision not to serve somebody they knew ought to be served.
You might not have refused leave on ground one if there had been a sort of bad faith kind of finding that she'd made, to put it another way.
I think I've just about hit my time, unless there's anything else. Those are my submissions.
Thank you. Yes, Mr. Bates.
4 points in reply, if I may. The first point is probably the central one, taking us back to analysing the task of imputing an intention to Parliament. And it stems out of an exchange my Lord Briggs had with both myself and Mr. Rainey this morning. One way of putting this, I think my Lord suggested, without nailing his colours to the mast, is that it might be said that the arguments in this case involve effectively implying in a provision that there's only invalidity if someone suffers prejudice, and possibly suffers prejudice and complains about it at a later date. Can I just make this clear now? Once we start getting into these discussions around trying to identify a need to show prejudice, around implying in provisions, this betrays the danger in this approach. We're imputing an intent based on the objective words and the context. We need, in my respectful submission, to be very careful about straying too far into what Judge Cook described as effectively legislating by implication of words. And the reason for the caution that I urge upon you is something that Mr. Rainey alluded to this morning. Context is everything. Mr. Rainey alluded to the different considerations that arise in criminal law, as opposed to property law, for example. Can I take you to page 607 in the main bundle? Because this context is something this court returns to on a regular basis. And in 607, we have an extract from the Manchester Ship Canal case, one of the many Manchester Ship Canal cases, concerning whether or not there were implied rights to discharge effluent and treated water into a private waterway. And at the end of 607, the last sentence, Lord Neuberger makes, one in my submission is a very well-known and well-established proposition, that there's a strong presumption that private rights are only to be taken away by a statute by means of clear and specific words. And where a statute deals in detail with the rights and obligations in a certain field, it's intended to be exhaustive. Now, I appreciate, of course, the context is different. We're talking about their discharge of effluent into private land. But the point is the same. You're being asked to countenance a situation in which private rights are to be removed in circumstances where Parliament said X was to happen and X did not happen. That ties into the second point I wanted to make, which is the role of prejudice in this imputation. The danger with placing the weight that certainly Mr. Jacob and sort of what Mr. Rainey puts upon actual prejudice is that it won't give you the predictability that Mr. Rainey urges upon you. It simply shifts the focus of the debate. Presently, the lawyers all stand up and argue about what Parliament intended. If the focus becomes on the prejudice in every single case, the argument will just be, well, how was I prejudiced in each individual case? You aren't going to get predictability by trying to focus on actual prejudice. You simply change the focus of the argument. But as it happens, there will always, I'm happy to be as stark as that, there will always be at least two forms of actual prejudice for landlords who are not served with claim notices. The first is that they lose the opportunity to join the RTM company at the earliest opportunity, because they won't be aware of the RTM process because they didn't get the claim notice. And remember that once the RTM is acquired, they have an unfettered right to join the company. I appreciate their voting.
That doesn't arise in every case. They may or may not be aware. So it won't apply to every landlord.
Well, then let me give you a second example then, my lord.
Well, just before you do, does the Act in terms say you can only join as a landlord if you've been served with a claim notice?
No, it doesn't. You can only join as a landlord once the RTM has been acquired.
Yes.
So the point is, without the claim
then all you have to do is put up a flag saying you're a landlord.
Without a claim notice, you don't know that the RTM has been acquired. Because it's acquired if no one serves a counter notice on the date specified in the claim notice, which you don't know because you didn't get the notice specifying that.
Well, that would be a very good argument of prejudice then.
Oh, well, I agree. I'm saying that's why I've said that there will always be actual prejudice. Mm-hmm. The second element of actual prejudice that will always arise is that the landlord loses the right to prepare for the handover, because under the claim notice, page 304, section 80, subsection 7, there's always a minimum of 3 months between the giving of the notice and the acquisition of the right to manage. If you go to the tribunal, there's always a 3-month period after it becomes a final tribunal decision. See section 90, subsection 4, page 313. That is to allow for the proper transfer of management. It's to allow for the transfer of funds. It's to allow for the matters that were troubling my Lord Stevens this morning, the discussions you need to have with contractors about what's going to happen. If you don't have the claim notice, you lose that transfer period. And that harms everyone, landlord and tenant.
But section 81(1) says the claim notice isn't invalidated by any inaccuracy about that. So the claim notice may signally fail to give that notice. And if it does fail to give that notice, the statute itself says it's not invalidated.
Well, it failed by an inaccuracy. So if they give the wrong date, it wouldn't be invalid. So if the date that should be specified for acquiring the RTM is the 1st of April and they give the 29th of March as the date, that wouldn't invalidate it. Query whether a total failure to provide any information at all would be an inaccuracy as opposed to an omission.
But the date is after the tribunal hearing, is it?
Yeah, so after the tribunal hearing, it's section 90, subsection 4.
Yeah.
So where the right to manage is acquired by virtue of a determination under section 84(5)(a), i.e. a tribunal hearing, the acquisition date is 3 months after the determination becomes final.
And how's that a problem for you if you were at the tribunal hearing anyway, even though you weren't served with the notice?
Well, if you're actually at the tribunal hearing, it is less of a problem for you. I've accepted, but that comes back to our discussion this morning. It ends up being happenstantial as to whether you knew or not, whether you knew about what was going on. And what all this is doing, if I may, and you see it's been common throughout the submissions this morning. The lawyers focus on the legalities of it, but this is a practical statute designed to transfer the management of a building. Why would an interpretation which harms the good management of that building be preferred? And eating into the time periods that Parliament has allowed for a handover is not consistent with good management.
Why would Parliament want the result to be that you're able to obstruct the process through a failure that might have caused you some inconvenience or difficulty, but in fact caused you none at all?
Because
the possibility that that might have happened doesn't seem a very secure foundation for invalidating the whole thing.
Well,
when it didn't.
The oddity in this case, my lord, and the oddity I suggest in many of the RTM cases, is nothing stops you as an RTM company accepting your claim is defective, doing whatever you need to withdraw your notice, and serving a fresh notice tomorrow. There's no bar, there's no time limit, there's no sanction that applies. You get this game being played a lot in enfranchisement cases, because if a claim notice is withdrawn, there's a 1-year bar to proceeding. And when property prices went up, that was a very good thing to have if you were a landlord. It may be less of a good thing now. But that game playing isn't allowed under this Act. You could serve a notice Monday, withdraw it Tuesday, notice Wednesday. This is a very, very easy Act to comply with.
Yeah, but it's still the cost. There are still going to be costs associated with that, and we saw from the consultation paper that one of the concerns was that landlords could, sitting on their rights, wear down the tenants by, in effect, imposing additional costs on them.
It's a different form of game playing.
One might say the costs involved in this case, for example, the costs involved in simply accepting that a landlord should have been served and serving them would have been significantly less than the cost of litigating all this.
Well, that's certainly true by now, I'm sure.
It's certainly true by now. Staying with prejudice for a moment, I do say, as I did this morning in particular to Lord Sales, the prejudice that's being considered in Senegi is the prejudice to the proper working of the Act rather than the facts of the case. Now, Mr. Jacob placed great weight...
If I can just bring you back to your first prejudice, and that is the loss of the opportunity to join at the earliest opportunity to the RTM.
Yes.
In the case of an intermediate landlord, it's presumably they're notified. Well, they've got to presumably pay their service charges to the new RTM.
Yes, an intermediate landlord will, of course, be a tenant under another lease, and it may well have obligations now to pay a service charge.
Well, you'd know immediately, wouldn't you? You'd know immediately the RTM was saying, by the way, pay your service charges to me, and then you could join it.
Well, again, without sending into the myriad of facts on different leases, you might have a lease that only allows for service charges once yearly in arrears. The modern practice of regular honour payment counts isn't something that we should assume always happens. So there may still be a delay. I don't pretend, as I haven't pretended when answering Lord Leggett's questions, that in individual factual scenarios you may not be able to cobble together an individually workable solution. But I say that's not the answer. It's what the legislative scheme requires, not happenstantially, what happens in each individual situation. Just briefly on Senegi, Mr. Jacob placed great weight on paragraph 23, and I think my Lord Sales did as well, suggesting that Lord Steyne was looking at the individual outcome for the individual accused in that case. Can I just ask you to look with how Lord Brown deals with paragraph 23? It's his paragraph 78 to the end of his speech. It's page 691 and following. Because Lord Brown, with whom Lord Steyne agrees, in my submission, considers that Lord Steyne was, in paragraph 23, is dealing with prejudice to the proper working of the Act, rather than individually to the factual scenario. But for your references, it's paragraph 78 to the end of Lord Brown's speech, page 691. My third point is on ground one, and a few points to pick up here on what Mr. Jacob said. I don't disagree that the policy objective is to have a simple procedure. What could be more simple than serving a notice as Parliament required? The problem in this case isn't a lack of simplicity or isn't complexity. It's that they didn't do it. It's not right, as my own friend did, to characterise the loss of rights as regards consents or otherwise as ancillary, as he did. The RTM removes a bundle of rights, all of which arise from being a landlord under a lease. Some of them are functions under leases, some of them are consents, some of them are statutory provisions. That the whole point of the RTM regime is that the existing position is being changed. And what the claim notice is doing is ensuring that the people who were affected by that know about it before that it happens. Qualifying tenants are in a slightly different position, and to pick up on the reason why they don't get to object, it's because they've already been given a chance to join the RTM company either on its formation or by service of the notice inviting participation. And the way they protect their interests is to join the company and vote at the meeting in the usual way. They don't get a blocking minority vote, as Mr. Rainey rightly said. It's inherent in the scheme that once you get to 50% plus one, those leaseholders can exercise their rights. But the way their rights are protected is by joining the company and having exactly the same voting weight as the other members. Finally, one of my lords, I forget who, I'm afraid, asked about the difference between may in section 79.2 and must in section 79.6. The interveners bundle at page 54, paragraph 90, has a case called Canary Gateway, which explains in the upper tribunal, which explains the importance of the may provision. And what it's been held is that if you haven't given each qualifying tenant a notice inviting participation at least 14 days before you serve your claim notice, then then 79.2 means you can't give the claim notice. It's a sanction. So you don't get into the Soneggi territory of trying to identify an intent. Parliament has already said you cannot give claim notices unless you have complied with these provisions. The final point to come back on, the last point on ground two. I hope there isn't a pleading point in here, and we'll provide a short bundle to you in the usual way. There's a slight confusion, I think, if I may, here. I don't need to distinguish Elim Court, because, of course, it's not binding upon you. Everyone agrees that you're applying the Soneggi test. There are differences between us as to the emphasis and the individual factors. We know there was no attempt to serve my client. That's common ground. It's in the SFI. And there's no, as far as it goes, there's no cross-appeal against Judge Cook's conclusion that it was an intentional decision. But the question for you, if we get to ground two, is in circumstances where Soneggi means that not every failure to comply with 79.6 results in invalidity, on the facts of this case, does invalidity flow? And that's just an assessment you'd make applying Soneggi on the basis of the findings of fact made below.
Well, do you accept that there was a ground one which you were refused permission on and
yes.
you can't re-argue?
Yes.
What was that?
What I'm going to ask, rather than try and guess it, we'll provide a short bundle of the pleadings below. But the critical point...
And the notice of appeal.
Of course, yes.
Which is by reference to which Judge Cook made her decision. Yes,
I'm happy to provide all that. But there was no attempt to serve. We know that it's common ground, and we also know why. It's the reason why there has to be discussion in some of the material below about attempting to distinguish Elim is because, of course, it was binding on both the first-tier tribunal and the upper tribunal. But, of course, it's not binding on you. And if we get to ground two, it's this court's decision applying Soneggi to the facts as found. My lords, can I just see if there's anything else to pick up on?
But before you do so, the Soneggi at 689, paragraph 67, letter E, Lord Caswell makes it clear that it is actual injustice that has to be considered. The actual impact.
Yes, when I did the old style totting up of who agreed with who, I I'm not sure that anybody else agrees with Lord Carswell, except certainly Lord Steyn only agrees with Lord Roger and Lord Brown. So I accept that.
I couldn't find the bit that you're relying on in Lord Brown's speech, so it would be helpful if you could actually flag up.
Let me take you then. It's in 691, page 691, starting at paragraph 78. Postulate then a non-compliant postponement of a confiscation proceedings, a postponement beyond the 6-month period without there being exceptions to justify a delay. What would be the consequences of that? Posing the ultimate question formulated by Lord Steyn, paragraph 23, so he's now picking up on what Lord Steyn said in paragraph 23, it's can Parliament, in these circumstances, fairly be tended to have intended total invalidity? And then my submission is, if you look at 79 and 80, he considers the working of the Act, not the individual fairness or otherwise to the individual complainant in that case. That's the point I wanted to take from it.
I mean, usually it's part of the purpose of an act like this that there should be fairness to an individual. I'm not sure that the distinction that you seem to be trying to draw between the workings of the act and fairness to the individual is a particularly persuasive one, if I may say so. Are you trying to say that acts are intended to be unfair and we should ignore fairness to the individual?
No. What I'm trying to establish is that there is a difficulty, a risk that arises if we start weighing individual prejudice in individual cases, because it simply moves the focus of the debate. And secondly, I say Senegi can be read as giving support for the proposition that in assessing prejudice, at least part of the assessment is the prejudice to the proper working of the Act. It's not as simple as has been suggested at times in argument. You simply look at the outcome for the individuals.
All I can say is Lord Carswell agreed with Lord Steyn, and he thought that that's exactly what Lord Steyn said at page 675, paragraph 15, letters C to D. To look at the actual impact.
Well, he did look at the actual impact in paragraph 24, Lord Steyn, when he referred to the prejudice to the two accused was not significant. So he obviously thought it was a factor.
Yeah. And paragraph 78, Lord Brown says, posing the ultimate question formulated by Lord Steyn, paragraph 23, can Parliament in these circumstances, and he means the actual circumstances of the case, fairly be taken to have intended total invalidity?
Absolutely.
Well, I suggest he's not excluding the proper working of the Act then, if I can put it that way.
Right. Okay.
But my lords, you've been more than patient, so unless I can help you with anything else.
No, thank you very much. And we're most grateful to all council and their supporting teams, including the intervening team, for their carefully prepared and very helpful submissions on this difficult piece of legislation. And we will take time to consider our judgment.